Good evening. My name is Carol Allman Morton, and I am Ollie's Executive Director, and I'm so glad to welcome you all to this Zoom room tonight. As we begin, with gratitude and humility, we acknowledge that those of us in the Berkshires are learning, speaking, and gathering on the ancestral homelands of the Mohican people, who are the indigenous peoples of this land. Despite tremendous hardship in being forced from here, today their community resides in Wisconsin and is known as the Stockbridge-Munsee community. We pay honor and respect to their ancestors past and present as we commit to building a more inclusive and equitable space for all. I have just a few short announcements and then we'll get started. To learn more about programming at Ollie at BCC, you can check out our website, berkshireollie.org. Some highlights include a talk with Sarah Vowell on April 8th on her book Lafayette in the Mostly United States, which will help kick off an 18-month series of programs on the 250th anniversary of the American Revolution and the 200th anniversary of Lafayette's visit to the Berkshires. That program is on Zoom and free and open to the public, so feel free to share it out with any friends or family who might be interested. Also coming up in our Distinguished Speaker Series, we have a talk tomorrow with James Ketterer from Bard College on Jazz Diplomacy, America's Conversation with the World. That's tomorrow at BCC. Austin Serrett from Amherst College will be offering a talk on Zoom called Is Democracy Doomed? On March 18th. Elaine Sciolino from the New York Times on her new book, The Art and History of the Louvre, will be speaking both in person in Housatonic and on Zoom on April 10th. Our spring semester of classes begins on March 31st and registration is now open. You can find that at berkshireollie.org/spring 2025. So tonight we first welcome Tom Gerety. We're so grateful that Tom reached out to his colleague Peter Shane and brought us this program tonight. Tom Gerety taught constitutional law through most of his career. He retired as Collegiate Professor of Law and Humanities at NYU. He headed up the Brennan Center for Justice and was president of both Trinity and Amherst Colleges. He earned law and philosophy degrees from Yale. And we also welcome Peter Shane, a leading scholar of administrative law and separation of powers. He retired as the Davis Chair at Ohio State's Moritz College of Law and now serves as Distinguished Scholar in Residence at New York University School of Law. His recent book is Democracy's Chief Executive, Interpreting the Constitution and Defining the Future of the Presidency. Shane earned his degrees at Harvard College and Yale Law School. He also has a podcast, Democracy's Chief Executive, on the American Presidency. Welcome to you both, and thank you.
Thank you, Carol. Peter, I think you're Peter, are you muted?
Rarely, but on that occasion, yes.
Okay. Let me introduce Peter by saying that he and I took constitutional law together at Yale Law School many long years ago at the latter end of the 70s, or in the middle of the 70s, I should say. And I have followed his work because he's one of the really distinguished students of separation of powers and the administrative state, the much despised by the hard right reactionaries, deep state or a broad state, I guess I would say, that characterizes not only this country, but just about any modern country in the world. And one of my theories here is that you just cannot have a proper functioning state, and I'm sure Peter would agree, without a really strong, smart, expert bureaucracy, whether in health or in Social Security and helping the aged, or indeed helping the military and so on, although we'll see in a moment that they're somewhat separated out. I wanted to start out, Peter and I have been going back and forth about how to start, and his first question or his first theme is, why the devil does Trump think he has the power to do this? I think all of us have been shocked by the rushing tide of executive orders and commands and so on, whether legal or not, that Trump has embarked upon. I think many of us have been surprised because it happened somewhat more recently that Elon Musk produced a kind of mashup of himself and Trump in the presidency, or as a counselor, supposedly, in the head of Doge, but in some ways as the person who's calling the shots. One of the things that struck me most in the last couple of weeks is the epitomization of Trump as a fibber in the recent de facto State of the Union speech. And it was as thick a tissue of lies exaggeration, examples that just had already been falsified a couple of weeks or days before, and so on, as I've ever seen coming out of Donald J. Trump. And it occasioned a lot of commentary about this notion that lies spread around the world quickly. Indeed, that lies are around the world before the truth is put on its boots. And I wanted to chase that down myself as a phrase. Where did it come from? It's been repeated by lots and lots of people. And the origin of it seems to be Jonathan Swift. And I just want to read you the paragraph that originated this in Swift as we started. Swift says, and this is in the late 18th century, besides, as the vilest writer has his readers, so the greatest liar has his believers. And it often happens that if a lie be believed only for an hour, it has done its work, and there is no farther occasion for it. Falsehood flies, and the truth comes limping after it, so that when men come to be undeceived, it is too late. The jest is over, and the tale has had its effect. I love this notion that the lie, because we see so much inconsistency in Trump's statements, orders, and so on and so forth, in his claims, that this notion that you can lie one moment and drop it an hour later and lie in another direction, and yet the harm will be done. The sort of baffling of the public as to what is reality here, what is the truth. So, Peter, let's start with what you think is the most basic question here. I think I've got you right. Why does Trump imagine, think maybe too strong words, that he has the power to do these manifold things once he arrives in the presidency?
Right. Well, there are two ways, I guess, of thinking about that question. One are the sort of political, economic, social circumstances that enable Trump. I think we could say that, part of why he's able to do what he's doing is that he knows he has the bottomless pockets of Elon Musk behind him, or aside him, or in front of him, or somewhere nearby, willing to threaten political retribution to anybody who dissents. And so, that's critical. And, we can talk about the larger political economy. Of course, what I've been focusing on in my own work has been the legal theories that he's relying on. And I think it's fair to say, in Trump's head is probably nothing more elaborate than what he said in the first administration, which is, there's this thing nobody talks about called Article 2, which lets me do whatever I want. And that may be his theory.
It's a succinct piece of a constitutional interpretation,
right,
as we've ever seen.
That's popular constitutionalism, Trump style. But what the legal thinkers surrounding him are subscribing to has come to be known as this thing called unitary executive theory. And Steve Calabrese at Northwestern, who was one of the originators of it, said, it's really a debate about whether we have only one president of the United States. That's not the debate. We only have one president of the United States, or at least putting Elon Musk aside, we formally have only one president of the United States. The question is what he's empowered to do by Article 2. And Unitarians in this sense, and I hate to cast aspersions on Unitarians, because there's a whole wonderful group of people who call themselves Unitarians. But what the Unitarians in this sense believe is that Article 2, in some way, maybe it's the vesting clause, maybe it's the supervisory role contemplated by the requirement that he take care that the laws be faithfully executed. But somewhere in there is implicit a kind of comprehensive power of supervision and control with regard to the rest of the executive branch. So, the executive branch, some of what it does because the president has been given specific things to do by the Constitution. That's why the executive branch can pardon people. It's why the executive branch can negotiate treaties. Those are presidential functions given to him directly by Article 2. But most of what the executive branch does, particularly in domestic affairs, it can only do because Congress has authorized the executive branch to do something through some kind of administrative statute. It's set up an office or an agency to accomplish a task. It is spelled out that task, sometimes very specifically, sometimes in very general terms. And when you hire anybody to do anything, paint my house, mow my lawn, there's always going to be some room for judgment. And that room for judgment can be very narrow. If I say, paint my house, that doesn't mean buy all new furniture. But even there, I'm not telling the painter what brushes to use or, when to use a roller. I'm trusting their judgment. And if I'm hiring someone like the EPA to protect the environment, obviously the room for judgment is going to be much broader. In legal terms, we call it discretion. So the idea of the unitary executive is basically that the president gets to control how all the discretionary judgment of the executive branch is exercised, whether it's exercised by him or somebody doing work for him in connection with his Article 2 tasks, or in the domestic context, whether it's somebody involved in protecting the environment, protecting civil rights, looking after worker safety, regulating the food, and whatever it is, the idea of the unitary executive is, the president gets to control it all.
Including the money, right, Peter? Or at least when we come to the topic called by this somewhat arcane name, impoundment, as in my car or my dog is in the pound, meaning imprisonment or jailing of funds, we're really dealing with an extension of discretion to expenditure as well. Congress allocates so many billions. The president says, I don't want to spend it on AIDS help in Africa, for instance, or what have you.
Yeah. So this theory sort of comes in different flavors. I was talking to somebody this afternoon who I think was right off a Starbucks run. So she was saying, oh, this is tall, grande, and vente versions of the unitary executive. But where the debate has been among legal historians and constitutional lawyers for a long time is really over whether the president's supervisory role includes the power to remove at will really anyone in the executive branch, directly or indirectly, but certainly at will, the heads of any agency within the executive branch. And that, the Supreme Court is weighing in on that. It's going to have opportunities to weigh in more just on the removal power. But, and this is a sort of weird, I think, unanticipated thing that happened. In the immunity opinion that the court handed down last June, which people were focusing on whether or not Trump as a former president could be prosecuted. But in the course of that opinion, the court said something, I would say carelessly, that has much bigger implications than immunity. It described, in some sense, it was repeating and pulling together ideas from earlier cases. But it said, number one, and this is key to the theory, the president is a one-person branch of government. Right. And in the president is vested not some, but all of the executive power. And some of that power that is vested directly by the Constitution is absolute in the sense that it's not susceptible either to congressional regulation or judicial review. And the court said in this case that includes his general supervisory power of supervision and control. Now, if that's true, and this is sort of weird and not going to be intuitive for a lot of people. Well, what that really means is when Congress gives the executive branch something to do, they're really giving it to the president. The president could, if the president chose, just take over the function. He could write the regulations himself. He could, conduct the Social Security hearings. That's absurd. That's never going to happen. But constitutionally, the thought is everything that the executive branch has been empowered to do, the president can control. This is the broadest theory. But under this broad theory, the ability of anybody in the executive branch to do anything becomes dependent not just on Congress having written the statute, but the president basically permitting it to go on because he hasn't taken it over. And that idea that everything that the executive branch does is as dependent on the president's will as Congress's will turns the separation of powers upside down.
Peter, let's just step back, if I may, with the listeners, trying to listen in as someone who's not as well informed as you are. I mean, one implication of that would be Congress's power to send money is a kind of like, send me the money and shut up, go away and shut up. And thus you get things like the impoundment theory, the theory that the president could say, well, you've allocated money here, but you didn't, that's all you can do. And I don't want to spend it. I don't want to do this work that you sent me funds to do. I used to give, and I'm sure you've done this, questions to con law students, which raise crazy, I mean, they're always crazy hypotheticals, but among the crazy hypotheticals, well, what if a president refuses to appoint anybody to the Supreme Court until they're all dead and we have no Supreme Court? Similarly, what if a president gets no funds from the Congress? So he couldn't, in other words, your vision of this, which I think is persuasive, is the framers intended this as a checks and balances operation, but a cooperative interaction among the branches. Is that a fair statement and of some of your work too and your thoughts?
Yes, very much. And I mentioned in one of our earlier conversations a quote that we actually, my co-author Hal Bruff, who's the former dean at Colorado, he and I have what is still the only casebook on separation of powers law. We used to think it should have been dedicated to Richard Nixon, without whom it might have been a pamphlet. But now, we're trying to keep it shorter than the World Book Encyclopedia, for those of you old enough to know what the World Book Encyclopedia was. But we have a prefatory quote, a sort of epigraph, is a quote from a British prime minister in the mid-19th century, Lord John Russell, who said that every political constitution in which different bodies share the supreme power. Now, the supreme power under the US Constitution, of course, is held by the people. The people are sovereign. But any constitution in which different bodies, different branches of government, share the supreme power is only enabled to exist by the forbearance of those among whom this power is distributed. In other words, the system can't operate if any branch takes to its limit the kind of thing, Tom, you were just talking about. Hey, under the Constitution, all we have to do is give the judges their salaries, give the president his salary. We're not appropriating a dime more. Congress literally could do that. The president, as you say, doesn't have to appoint anybody to the Supreme Court. This president, our current president, I think, is happy to fire and not replace people as one way of disabling agencies. The court could decide, every piece of legislation we see these days looks unconstitutional. Let's just void it all, without any regard to the deference we owe to other branches. Any of that behavior would destabilize the system.
And Peter, what's your, go ahead, I didn't mean to interrupt.
No, I was just going to say, with regard to the impoundment thing, which is interesting, of course, and very consequential, a couple of things. Number one, there are two clauses in the Constitution that hammer home that the power of the purse belongs to Congress. Both the spending clause that allows it to spend money and another clause that says the executive branch can't spend any money unless it's been appropriated by Congress. Early on in the Republic, it is true that when Congress was relying on basically income from customs to cover the federal budget, it was understood that the president, if expenditures were going to outpace the revenue, could cut back. But this was done pursuant to the authority that was understood to have been conferred by Congress. This was not thought to be inherent presidential power. And so, to the extent that they're relying on, the way things operated in the early 19th century, that history is not going to support the argument.
Peter, what we should just say for anyone who's having a trouble with some of the language here. The vesting clause. It says in the Constitution, in Article 2, which is the presidential or executive article, that the executive power shall be vested in a president. And what Unitarians, as Peter is calling them, do is take that because there was an argument. Should we have a committee? Should we have 2 or 3? Should we have some kind of division at the top of those responsible for execution? Mindful of Lord Russell's warning there about forbearance. And it's sort of like what you see in corporate law or corporate practice when you get 2 CEOs. Sooner or later, they start to bicker and feud and things split up. We've seen this over and over again, whether it's Apple or IBM or anywhere else. It's a commonplace, maybe of human nature and psychology, that it's damned hard to share the CEO powers. Well, Musk comes along with the huge infusion of cash and a seemingly sudden outburst of very, very strong political opinion, speaking to the Alternative for Deutschland, the Nazified Party, claiming that they're the salvation of Europe, cursing out Ukraine and so on. Musk comes along with all his money, and all of a sudden, we've got a very strange example of the president's appointments power. And everybody here should know that in the Constitution, it says that principal officers require the approval of the Senate, the confirmation power. So what do you make of, this, I think most people are listening in this may be the most shocking thing, that we have what people have, probably caricatured as a co-presidency, but we certainly have an odd psychosocial relationship between these 2 men. And it's often not clear to me who's really coming up with the ideas and pushing them forward. I keep thinking of the fact that Russia's great example of this includes within his name the name Putin, Rasputin, and we have a kind of Rasputin. We're a very rich one, more many times richer than Trump ever thought of being, or maybe ever was. But what do you think, Peter, of this feature of the presidency that we have right now, and its constitutionality, and its place in our history?
Well, I would say a couple of things. One is, you mentioned how much emphasis the Unitarians place on the word but it's Article 2, so there are 2 articles in that sentence. There's also the word the, and it's the combination of the and that supposedly is doing all the work. And it's amazing how much emphasis is placed on the executive power is vested in a president of the United States. My own contention is that if they left the word the off, the sentence would mean exactly the same thing. What's your favorite part of the meal? The dessert. What's your favorite part of the meal? Dessert. Means exactly the same thing.
Yeah.
But so it is true that at the time the Article 2 was drafted, the folks doing the drafting were inventing something new. And they had much clearer ideas of what they did not want than what they did. They did not want, as you say, they did not want a kind of council of revision kind of system or a plural executive that they had seen operating in some of the states between 1776 and 1787. But they also didn't want a king. They didn't want someone who would be overly dependent on Congress, but they didn't want someone utterly autonomous and not subject to regulation by Congress. And so Article 2 does have a certain kind of Delphic quality to it, because unlike Article 1, which is pretty specific about the features of the legislative branch, how it's going to be organized, what it's allowed to do, Article 2 is pretty much a sketch. Now, when it comes to unitary executive theory, I like to say that there are really only 4 things about it that I have a problem with. Thing number 1 is that the proposition that the president is a one-person executive branch is refuted by the text of Article 2. Article 2 goes on to say that the president shall have the power to obtain the opinions in writing of the heads of executive departments with regard to the duties that they have been assigned. Now, that must refer to duties assigned by Congress. It wouldn't make sense to say he can ask for the opinions in writing, with regard to the duties that he's assigned. That would be a ridiculous kind of formulation. So it sounds like these executive departments are, someplace else in the executive branch. And also, the idea that he has all of the executive power. This starts with a quote from Scalia. Said, the executive power means all the executive power, not some of the executive power. Again, just read the next paragraph of Article 2. You know that this isn't true, because the Senate explicitly is given the authority to share in the appointments power by confirmation, and the treaty-making power, another executive power. They share that because treaties have to be approved by the Senate. So at the very most, Article 2 gives the president executive power that is not otherwise limited or shared other places of the Constitution, which raises the question, where might we look for that? The second thing I have, so the text to me doesn't align very well with unitary executive theory. The second thing is that the folks who have championed this theory, which really only began to take off with the Reagan administration for reasons we can talk about later, say that this is, reading the Constitution as it would have been understood in 1789.
Right.
And even if this were the correct reading, which I think it is not, and actually that's another objection. I think they're misunderstanding the founding period. But even if they were correctly understanding it, what they would be correctly understanding is the relationship between the president and a federal bureaucracy that had very little reach into people's everyday lives, or into the economy. A couple thousand people, probably smaller than the smallest cabinet department today. Today, we have a civilian bureaucracy, even after the DOJ cuts, probably as large as the population of the United States in 1789. Why we would want to think we were bound to understand the relationship of the president to that bureaucracy the way people would have understood that relationship in 1787 is puzzling. The third thing, as I said, is I think they've got the history wrong. The fourth thing is it was sort of, I don't want to say it's obvious, but it wasn't hard to anticipate, at least for some of us, how the modest view, the tall version, not the vente version, how the tall version of unitary executive theory could metastasize into something that we're now experiencing on a day-to-day basis. So my first sort of book on the presidency, other than a case book, I wrote in 2009. It was called Madison's Nightmare. I was going to call the second book Madison's Nightmare 2, I Told You So, only because so much of what seemed hypothetically dangerous in 2009, we are now witnessing.
So come back. I'm going to bring you back to my question about Musk then. Is Musk a legitimate actor in all of this, do you think? I mean, how do you appraise Musk's juncture with Trump in this Rasputin kind of role? I mean, Trump has done a couple of things that put aside the law and the Constitution for that are just shocking. I mean, commentators in foreign affairs have said this is the first president since, the Second World War who's basically allied with the Stalinists, with the revived version of a Russian empire and a Soviet empire, if you will, or one that's seeking to be such on a smaller basis. And where do you see this? I mean, is there a chance that the appointments power notion that principal officers of the government must go in front? Now, admittedly, perhaps the Senate is supine, and we will get confirmations as we've gotten 51 to 52 to 48 or whatever. But is he legitimately playing a role? I was really struck, as you must have been, by the court hearings in which the Justice Department's lawyer couldn't answer questions about who's in charge. And we give what? Well, I'm not sure who's the head of DOGE. Now, Trump has just said yesterday, I think, that Musk is the head of DOGE, but then there's another person named Gleason, who's a federal civil servant who's hung on and joined the Trump team, who's the titular head of DOGE. Where do you? It's a very strange kind of power that he has. Denied whenever challenged, but absolutely there in manifold ways, day by day.
So I'm feeling bad about this. We have, you may know, there's a historian at NYU. Her first name is Ruth. This is why I sort of think of her as Ruth, but even though I hardly know her, but she's written about the history of fascism. And she's
an expert on Mussolini and Italian. Many of you will have seen her on PBS or heard her on NPR.
Right.
And she's got real expertise on particularly Italian fascism, which is most of us think of as the origins of the term. It is the origin of the term, but also of the origin of the movement that then was put on much more forceful and harsh and in the Holocaust and Hitler. But go ahead.
So she has identified the incorporation of a private citizen to play whatever role Musk is playing as kind of the unique innovation in America's authoritarian turn. Huh. And I do think that, the appointments clause ought to play a role here. One of the things that's sort of interesting, the Roberts Court is been kind of hyper formalist in reading the text of Article 2. In the last 20 years, the jurisprudence surrounding who is reached by the appointments clause, who's an inferior officer, who's a principal officer, who's an employee, the removal, all of this has gotten much more complicated because they want to be hyper technical. Well,
let me just clarify, meaning for those of you who are listening, that if you ain't confirmed by the Senate, you should have damn little power, right, Peter?
Right.
Administrative judges and so on. In other words, none of it, you can't get away running an executive branch with lesser, I mean much lesser officers making decisions unless they've been confirmed. And that leads to this question. That's your formalism, I think, if I've understood you right.
Right. But I want to push that even further. In order for anyone to make binding decisions that bind members of the executive branch or members of the general public on behalf of the United States, they have to be an officer of the United States. Now, the people who report only to the president, we now call principal officers. And principal officers, like the secretary of something, a member of the National Labor Relations Board, those people, those are principal officers. They have to go through advice and consent in the Senate. But even the people who are not in charge of something, people who report to the Attorney General, they report to the Secretary of State, we call them inferior officers. And Congress is allowed by Article 2 to, they can insist on advice and consent for inferior officers if they want to, but they could also allow the president to appoint by himself, or they could allow the head of a department or a court of law to make the appointment. But the key thing is they're being appointed to an office created by law. There is no office that has been created to which, Musk has been appointed. And one of the things we see in the second Trump administration that was bedeviling his lawyers in the first administration is that the lawyers who are trying to argue within the conventional terms of public law, are trying to, slice the bologna. So, he's not making the final decisions. He's just advising. He's just communicating with the president. After presidents get to talk to whoever they want, if he wants to take advice from,
his wife or the guy in the
or
store, the guy in the bar, or whatever. Yeah.
In the Brooklyn detention center, whatever, he can do any of that. But if they're going to be an officer, they have to fulfill an office. And as you said, the lawyers are trying to say, no. He's just giving advice. He's just giving ideas. And then Trump comes along and says, no, he's in charge. He reports only to me. That's the definition of being a principal officer. So I think this could cause problems.
Meaning could cause reversals by courts, by federal district courts and appeals courts and the Supreme Court ultimately.
If it is determined by the court that actually Musk ordered the firing of people, then the firing was unlawful. Now, in the real world, again, because his pockets are so deep, his megaphone is so loud because he owns X. There are so many people willing on his behalf to threaten the personal security and livelihood and lives of the opposition, that, it's like, we're in this constant situation of, will no one rid me of this meddlesome priest? You don't have to give orders in order to be the effective decision maker. And whether Musk is ultimately going to be controllable in that sense will be interesting. It's interesting to also to see that the cabinet is now rebelling a little against this.
Stirring a bit. And the pardoning of January 6th, of course, which may be ultimately seen by historians as perhaps the worst thing that happened in this period of the American presidency, unleashes a kind of amateur militia. And maybe this is Ruth Ben Guyot's sort of concept there of who we all know that the Proud Boys in particular, but numbers of these people are crazed enough, like the guy going into the pizza place up in Northwest Washington with a shotgun, looking for Hillary and a coterie of pedophiles, that there's real danger in this, how would you call it, kind of, it reminds me of it back in segregation days when Eisenhower sent the troops to Arkansas to desegregate the Little Rock schools. Orville Faubus was playing this role of, gee, I don't have any responsibility here. And then seemingly on the sly, arousing the amateur troops to raise hell and protest the desegregation itself. It is, to me, people have talked, and I think you may have touched on this in some of your writings, what exactly is going on here? And lately I've noticed in the New York Times this term patrimonialism, trying to describe this anthropology of government in which you get personal loyalty above all else, the family. And my own reaction has sometimes been, it's basic gang logic. It doesn't require a fancy term. It's Don, old J. Trump, is the Don. And everybody who joins him owes their careers, their positions, their power, and to some extent their future. Because if you are an apostate and betray him, he can really go after you in various ways. And it is an extraordinarily, to me, gang-like procedure for insisting that I'm going to appoint people who owe everything to me. Kash Patel would never have been appointed by previous presidents to the FBI head, et cetera, et cetera, et cetera. You go right down the list. It's cronies, as they say, turtles all the way down. It's cronies all the way around.
It is quite the threatening situation, and there's no doubt that what Trump hopes to do is to have this operate again from the highest levels of government down through the civil service. I know you're probably aware, and maybe a lot of the audience who's listening to us is aware of what's called the Schedule F idea. Right. So the civil service, this very large group of people now, is divided into different groups in terms of their employment status. There are people who get their jobs in part by taking a competitive exam, and they are protected against at-will discharge as employees or inferior officers. And we call, if they're taking that exam and that's how they get in, we call that the competitive service. And then there are people who are accepted or exempted from having to do that, and we call that the accepted service. And the accepted service itself has, different different lineups, different schedules is the word, and they make perfect sense. Like there's some jobs in which it just you need a specialist for which a competitive exam isn't feasible, or there's some people who are being hired really as confidential advisors, and the Secretary of State is entitled to a confidential advisor who doesn't have to take a competitive exam. All of that's sort of fine. But what Trump wants to do is take all of the professionals in the federal government whose work can influence policy. They're not making the policy decisions, but they're doing the economic analysis or the statistical analysis or the epidemiological analysis or the biometric, whatever.
The environmental analysis to take the greatest crisis we may face in the next century.
Right. Climate change is happening, really, you think? So all of that, he wants those people who are now part of the competitive service or part of the accepted service, but some of the people in the accepted service still have job protection. Those people who are doing the kind of rare expertise things, that's why they were hired outside the competitive exams. Those people are protected against at-will discharge. Well, he wants to take anybody in that group and move it into another part of the accepted service that can be fired at will. And this would completely upend the idea of having a civil service. And it would greatly reduce the capacity, and it's partly intended to reduce the capacity of government to get anything accomplished. One thing, I suppose anybody who's been doing this long enough has their pet peeves, and I'll mention one of mine. It is common among, people of a certain political view to say that what the framers really wanted out of the Constitution was freedom. Yes, they wanted freedom, but they also wanted effectiveness. They wanted a government that could address the problems of the nation and address them in ways that would actually ameliorate and attack those problems. Article 1, the powers that were given to Congress, that was just the committee on detail spelling out a general resolution to make a government that was competent to address the problems of the nation that states could not solve on a state-by-state basis. And this sabotage, this self-incapacitation of government just is completely antagonistic to what was supposed to happen. And the fact that all of the agencies that had investigations going with regard to Musk's business enterprises have been attacked.
Yeah, to give a couple of analogies that make it vivid for me, and I hope will make it vivid for the listeners. Peter spent more time than I did as a scholar, professor, and tenured officer of universities, where he couldn't be fired for just any reason. I kind of gulped when I became a college president and was told by the first and second boards I worked for, you're fireable at will. We don't like you one day, you're out of here, just like an NFL quarterback or something. If you get intercepted too many times, we can't, you're out. And so this notion of at will employment, which a lot of people, to be honest, have to suffer through, maybe more in the United States than in Europe, but it really does affect one. And in many, many settings, including corporations, mostly it's only at the very top that we have this notion that you can be fired just for the cut of your jib on a given day. I think many of the listeners here will feel that it's not right that a person who's done good work. I mean, you see again and again in these Musk emails that become preposterous after a while, that they're using just sort of copied text to say, we found you to not be doing a good job, therefore you're fired. And the person says, wait a minute, my last evaluation was I was a real hero of American labor here, right, in the Veterans Affairs or whatever. Do you think, Peter, one of the big questions here on people's minds and on your mind and mine is the Roberts Court and ultimately how the federal judiciary will hold up. It seems like we're getting at the district level in the preliminary judgments in the many cases, I mean, new cases virtually every day. We're getting judges appointed by Trump, appointed by the Bushes, appointed by even by Reagan in the case of Judge Conor out there, who took up the birthright citizenship in the first instance. We're getting a judiciary that is at least standing up. Now, that doesn't mean as it makes its way all the way to the Supreme Court, that there will be a strong stand and resistance to Trump's executive orders or impulses. Peter and I earlier talked about birthright citizenship, and we both think that that is secure regardless of Trump's, to me, vain and vainglorious executive order, that it will withstand, and there will be people on the right side of the Supreme Court, hopefully one hopes all of them, but certainly some of them who will give a majority to upholding the long, now very long tradition, more than a century, that if you're born here, you're a citizen of the United States. But what do you think, Peter? I mean, the Roberts Court, that immunity decision was scary to a lot of us. It was very vague, and it seemed to suggest it was going to be really, really difficult to have any criminal liability in a president unless that president had been impeached and convicted.
Yes, and and I do think I would like to think that in practical terms, we have a president now to whom that holding was directly relevant. We had another one, back in the late 60s, early 70s. But one hopes that it's not a administration in, administration out concern that we have yet another former president we wish we could prosecute. I do think it's the general theory of the presidency and how expansively it was described in the opinion that is, the yet scarier part in operational terms. And the big surprise, frankly, to me in that is that it was written by Roberts.
Me too.
Right, because he is widely advertised as an institutionalist, but a couple of things to be said about this. First of all, Roberts was himself a White House lawyer during the Reagan administration. Alito was in the Office of Legal Counsel at Justice. They were both early champions of this unitary executive theory. And clearly, this is something in which Roberts has a lot of intellectual and emotional investment. I would just want to interject one thing about that. There's a decision that was decided a few years ago called SELA law against the Consumer Finance Protection Bureau, in which the court held that if an agency had a single head, a single director, like the administrator of the EPA or the director of the Consumer Finance Protection Bureau, that person had to be fireable at will by the president. And this is one of the opinions in which Roberts again writes the opinion. He lays out his theory of the executive, and again appeals to this idea of originalism. And in it, he actually says, and I swear I am not making this up, he describes the design of Article 2 as intended to make the president the single most democratically accountable officer of the government. Now, let's think about 1787. The only democratic, directly electorally accountable members of the government were the members of the House of Representatives. They're the only ones directly accountable to voters. The senators were chosen by state senates.
State legislatures.
Right.
Yeah.
Right. By the Senate, by the state, by the legislature.
By the legislatures of the states. Yeah.
Right. So you could say, okay, they're democratically accountable because they're accountable to somebody who got elected. The president is not selected by them either. They're selected. He's going to be elected by these electors, and the electors are going to be chosen by some process that is chosen by the state legislatures. So he is actually the least democratically accountable member of government. So again, I'm just harping back to the idea that this is a complete misrepresentation of 1787. And now, so this is the problem about going off in a tangent. I'm wondering where that original through line was. We were talking about, what were we talking about, Tom?
Well, let me bring it back. I mean,
Yeah.
Everybody should know that the Reagan administration and,
Oh, yes, I'm sorry. We were talking
and
about
Meese and company, Edwin Meese, who was Attorney General, you had these twins born, like Romulus and Remus. Originalism, I don't mean born, others had argued this way, but there really was a kind of birth of two, I mean, originalism first, and then a main feature of originalism, as we see now, is this somewhat, I would call it almost religious or fundamentalistic notion that there is a president who has all of the executive power. And these larger notions that they didn't want a monarch, that they wanted checks and balances. I don't know if you took any courses with Charles Black's, the great Texan at Yale Law School, but a guy who really thought, you got to think about the darn structure here. Don't just give me an article like or the. What are they structuring here? And if you're structuring a balanced, checked and balanced government, it has to be, as you said earlier, cooperative. It has to have powers distributed. There has to be a kind of dialogue or three-way discussion going on to make sure we don't end up with a monarch. And one of the key sort of avenues for this has been foreign affairs and military affairs, where many an argument has been had about the president should be the only one in charge, the one who, sort of like the pardon power, very arbitrary discretionary power that can't be checked. And Peter, I think one of the great things about your work is that you're both a critic of originalism, with your notion that following John Marshall, we should have an adaptive, a constitution that can change over time as the government gets bigger and so on and more complex. But also you're very, very tough on the kind of religion or cult of originalism.
Right. So, and just to say two things about this. So to go back again to the Reagan administration, I mean, one of the puzzles here historically, Tom, I think we would both agree, is that the position that the president should have all of this power would have been understood. Well, it would have been understood at the time Humphrey's executor was decided. This is the case that upheld the constitutionality of the FTC in 1935. The argument was made that having a federal trade commission where you couldn't fire people at will, maybe we should even talk more about that case. But so when that was decided in 1935, what we now think of as unitary executive theory would have been the New Deal position, right? When Roosevelt was being accused by the Hoover Republicans of being a dictator, it was because he wanted to argue for this very assertive, very aggressive, expansive view of executive power. How did this come to be the conservative position, beginning with the Reagan administration? And I think that the most succinct way of putting it, it's coming out in a book this spring by two political scientists, William Howell at Chicago and Terry Moe out at Stanford. They say, look, they start from the premise that every president wants to make a mark, right? Every president wants to fulfill his promises, be known in history for having done something important. Since, the 50s, but especially going into the 60s and 70s, where you have a progressive president, and I would include, Eisenhower and even Nixon in this, but we have a president who wants to accomplish things. They don't have to make novel constitutional arguments to support that. Congress has started passing a lot of statutes to get things done. The environmental movement, the women's movement, the civil rights movement, the consumer movement, all of these movements produced statutes that empowered the executive branch to address national problems in a pretty vigorous way. Presidents who want to get things done are going to try to interpret those statutes broadly, and sometimes they may get pushed back by the courts. But we don't think of that as a constitutional crisis. That's just, they overstepped what a statute means. The court says no. If you in this period, want to undermine the role of the federal government. You want it to do less. You want to incapacitate it in some way. Well, there's no statute that's going to allow you to do that. There's no, national self-sabotage act that allows the president basically to pull back on this law that he's supposed to be faithfully executing. And so that's vacuum. The idea that, if you want to shrink government in the way that Reagan, may have hoped for in relatively modest terms now as we look back on it, but, his successors have really wanted to double down on. That's where you need this sort of very expansive view of executive power. And I want to say something else about the text. So, as you said, it's a president of the United States. It's the executive power. Okay, so let's think about this. The president has the power to seek the opinions in writing of the heads of departments. Okay, that means he's not executing the law himself, right? The duties have been assigned to these executive departments. Now, if you're looking for the word all, and just one point, so it says, yes, the executive power shall be vested in a president. Article 1, by the way, which sets up Congress, says all the legislative powers herein granted shall be vested in. Article 3 for the court says the judicial power of the United States shall be vested in. The only word that's doing any of that work at the beginning of Article 2 is the word the.
Yeah.
But you know where you can find the word all? You can find the word all in Article 1, Section 8, Clause 13, I think, maybe 18, that says that Congress shall have the power to to enact all laws necessary and proper for carrying into execution all powers of the United States, all powers vested by this Constitution in any department or officer thereof. That's where the comprehensiveness is. The comprehensiveness is in Congress's implicit power to structure government and allocate the functions that are going to be carried out under presidential supervision, to be sure. But the president's job is going to be to take care that the laws be faithfully executed, not by himself, but by the executive departments. That's the text.
It is. I had mentioned this to Peter in another of our conversations. The confluence of Trump and Musk involves also, I think, a confluence of ideologies as well as personalities, and they may have very similar personalities, actually. And the tech bro libertarianism that we see in Peter Thiel and some of these other guys, but notably in Musk on X and his use of his money and so on, is something that I think most of us, Trump was an easy critic, a casual critic of all sorts of things about government. And like a lot of people in business, he didn't like regulations even when he was a young man building buildings, and he would defy many of regulation or disobey them and say, come after me and I'll sue you, and so on and so forth. But I do think there's an extraordinary and rather sudden confluence of real outright starve the beast libertarianism. That government is best, which governs least. And I don't know what Jefferson meant by that, but these guys seem to really want to reduce the government to a very, very thin and ragged operation under this all-powerful executive. And one of my personal peeves about this in terms of left-right politics and discussing political philosophy is that, I'll just put it bluntly, I don't believe you can have a good modern state, a functioning modern state, without a sizable government. And what we hear on the right when they go after the IRS and try to cut back taxes and give away money to the rich and so on and so forth is this inconsistency in which they want the hard right seems to want a rather small government generally, but a huge military that will dominate the world and be bigger than China's and so on. And it's radically inconsistent with practicality. And Trump, in that way, as in Jonathan Swift's notion that the lies can only last an hour, thus be very inconsistent, Trump is a very inconsistent operator in all this, even as he is, I think, an extraordinarily, I mean, the power he has over his party. We haven't mentioned, Peter, this notion that the Federalist Papers and Madison and Hamilton were very, very concerned about faction, but naive about how it might arise. Right. Madison, as many of you may know, thought that the large sphere, as he put it, the size of the United States, would mean a diffuse set of interests, a kind of regionalism, perhaps, or localism, a la Tip O'Neill, all politics is local. But clearly, that is not the case in this continental country that we're in here of the United States. Clearly now, with social media, we have large factions called parties that are really incredibly non-cooperative one with another. And I personally would have to put the blame on one side rather than the other, but it's extraordinary how different it has turned out. Their notion that we would get factions would produce demagogues would produce tyranny. We needed to check and balance this. Far from worshiping them, they clearly did not. They anticipated it as a horror, just as the classical theorists like Plato did, but they didn't really assure us that our government could resist a demagogue. And it seems for the moment as if we're not resisting very well. Does that make sense to you, Peter, or would you refine that or add nuance to it?
Well, what you say does make sense to me. I would say, again, just to share some of what we were talking about, in another conversation. Other people, other commentators looking at the current administration have sort of described it as being a confluence, not just of Trump's personal yearning to be
all power
and end all of power, and what you call the tech bro libertarianism, but there's also this third strain of Christian nationalism.
Yes,
and there in that convergence of these three things, there's a lot of contradiction, because yes, the tech bros, they're all libertarian when it comes to regulating their businesses, but the Christian nationalists, they want to squeeze every acknowledgement of achievement by anyone who is not white and male. They want to squeeze that out of the curriculum of educational institutions from K to 16 and beyond. They want to deport student protesters, even if they have achieved permanent resident alien status. If they're from another country, they want Trump is issuing punitive executive orders to investigate particular law firms that have represented clients adverse to his interests. The FBI Kash Patel says, I'm not going to have an enemies list except for the one I've already published. This business of the Trump government is libertarian. Ask the women of Texas who can't get medical care while pregnant because their doctors are scared out of their minds about the susceptibility to criminal prosecution, even if they help someone in dire distress. That doesn't feel like freedom.
No, I have a good friend whose daughter-in-law wouldn't go to a wedding in Houston because she was in the 7th or 8th month and was worried that, oh my God, if some crisis occurs, instead of getting medical care, I will get some kind of legalistic, oppression and may not be able to escape the state in some sense. Yeah, I think that's really a good point, that call it an ideology if you will, but it's just wildly, well, again, let me cite Jonathan Swift. The lie can just last a little bit. It's a rhetorical gesture over here towards libertarianism and an actual policy over here towards tyranny or oppression or bossing us around in our personal lives and so on, telling trans people or LGBTQ and so on, you toe the line here or else, and you can't serve in the military and you can't do this. Adelia was just saying, I did not see the headline that there's a move now to shut down the the Federal Civil Rights Museum down south. And
the Voting Rights Museum.
Yeah, it's extraordinary, just reaching out. I mean, just trivial things, you know, I mean, this is that pettifogging way Trump has of avenging whatever bothered him in some other part of his life, or that comes within his notice on Fox News or something.
Well, I saw a report, and just to show how, you know, I would, you know, I would love to be able to administer a test to anybody who is, you know, going after critical race theory. Before you do that, could you just give me a definition of critical race theory? Just mentioning race. They don't know what they don't know what they're doing, and a lot of it would be comical if it weren't so serious and so injurious to people. I mean,
so vindictive, really. Yeah,
and vindictive. But you've seen. I mean, I saw one report that, you know, in deciding, you know, what images to scrub out of some, you know, online military gallery of photos, they actually were going to take down the photo of the Enola Gay, which is the
because of the word gay. Yeah,
right. This is
the bomber over Hiroshima
right.
and Nagasaki. Yeah,
and then somebody joked, well, it's going to have to be called the Enola Strait from now on.
Yeah, yeah. Now, this conversation is coming to a point where we really should open up to see what. Now, there are a lot of you on this, and by the way, I've gotten texts as we've been talking from what I'll call complainants, both in my family and from friends, saying, "What the devil's wrong with Ollie? I can't get on this site." And Peter, you should know that they had to cap it at 1250, so that they simply didn't have room in their Zoom contract to go beyond that. But it will be recorded. Tell your friends that if they want to hear Peter on all these subjects, that it will be recorded, and they usually put out the recordings, and I'll send out links to my friends and family in the next day or two. But Carol, why don't you come on and give us some of the themes that people want to ask about here?
Sure. So top question, it came through in a bunch of different ways, but there's a number of questions about the president functioning as a king or a dictator, and if Congress is unwilling to push back on presidential power, is there any other recourse? And there was a corollary question about whether Congress has given away their power due to intimidation.
Well, the founding theory, as explained by Madison, was that, as he put it, the three branches were designed so ambition would counteract ambition. And what Madison meant by that is that each branch would be sufficiently protective of its own powers and prerogatives that it would resist too aggressive an encroachment from the other branches. The current Congress is utterly supine. They're not doing any meaningful oversight that I can see into any of the kinds of things that Tom, you mentioned at the start of the hour. So there's that. You have people who are being appointed who are, as one pundit said, they're not just unqualified, they're anti-qualified. You know,
that's their qualification. Yeah.
Right. People who would never have been let near any of these positions of responsibility in any other administration. The impeachment power is a nullity. Even if, so if the Democrats retook the House in 2026, even if they retook the Senate, which seems numerically less likely, but even if they had them both, they're not going to have 2/3 of the Senate. So Trump, even if he earns himself a third impeachment, and cements his place in the Guinness Book of World Records for that, he knows he's not going to be removed from office. So in a situation where you have the same party in charge of both the House and the Senate and the White House, and the party in Congress is, if anything, eager to abdicate its authority and allow the president to do whatever he wants because that's where they think the votes are, it really does reduce the force of any constitutional guardrails. It's amazing to hear the chair of the House Appropriations Committee applauding the idea of presidential impoundment, which is undermining his own constitutional function. It's just mind-blowing. Now, the question then comes up, well, you know, is he going to defy the courts? What will he do? So far, the administration is using techniques that other administrations, to be honest, have occasionally used, not as often, not as relentlessly, not as across as wide a range of actions, where like if there's an order, let me interpret it kind of super technically to say, oh, I'm not really disobeying it because there is space between A and B that I'm kind of walking through, and just try to drag things out that way. There are these evasive techniques. There are things courts can do in response. The most thorough study of official defiance of court orders was recently published by a wonderful legal historian at Yale named Nick Perillo. And Nick looked at there were 10,000 of these cases across the centuries. And it is true that courts can hold someone in contempt. They're reluctant to jail officials, although technically they could do that. They can impose, if they impose civil contempt can't be pardoned. The president can only pardon crimes. He can't pardon civil contempt. So there are things that could be done. This may be my own expression of naivete. I don't think if push comes to ultimate shove, that is, if the Supreme Court actually writes an opinion that says, President of the United States, here is a judgment that requires you to do A, B, and C, I don't think that Trump is going to say, I don't have to. I think delay and evasion, which have been his modus operandi in private litigation, will continue to be, what he does. I don't think that there would be, an outright, thank you, John Roberts, but I'm not doing that.
Many people in my acquaintance fear, what in Latin America is called an autogolpe, a self-coup, golpe being a blow in Spanish. And I lived in Peru when I was young, and Fujimori was said to have performed or tried an autogolpe, a self. Do you fear, he is certainly making brazenly odd appointments of the military, starting with Hegseth and going all the way down, whereas many of us learned in his first term to see General Milley and others as the officer corps at large of the military as a safeguard of democracy, really insistent on staying out of a lot of politics, trying to assure we didn't start a nuclear war haphazardly with China and so on and so forth. Do you fear an autogolpe?
So, there's a lot of publicity, of course, around the firing of the heads of the military branches. But at the same time, our Secretary of Defense, our anti-qualified Secretary of Defense, also fired the heads of the Judge Advocate General Corps within each of the services, basically the top lawyers. And you ask yourself, what was he thinking they would get in the way of? Now, I will say, one of the underappreciated stories of the whole sorry history of Guantanamo is the honor of JAG lawyers who really fought zealously for the rights of their criminal defendants. It's an astonishing story of selflessness on their part.
Because their careers were often imperiled by brave judgments.
Yeah, absolutely. So what is it that, they're trying to pave the way for? And I guess I want to say, and I try not to be a conspiracy theory kind of a guy, but I do think that there's part of Trump that fantasizes about the ability to use the military to impose violence on Americans. And I wish I could say that was 0% fanciful. It's not 0%.
No, it's certainly going beyond American citizens under the 14th Amendment, persons in the United States. It would seem that there's a tremendous impatience with any process, any due process or fairness in evaluating. And there was that article, I think in the Times, but it may have been the Post, of a recently kidnapped Mexican businessman coming to the bridge across into the United States and being told, go away, when he was saying, look, I've got my wounds right here on my arms. I've been kidnapped and threatened with death. Could you please shelter me? And they said, no, go back. There is no more asylum, apparently, the border guard said. I mean, I agree. It's one wants, in teaching constitutional law, I used to always say to my students, points for opposition. One wants to give full breast views that differ with mine. And I'm sure there are comments here saying that you and I are too much in accord. But it's really hard for someone who cares about constitutionalism and orderly procedures and due process and fairness to say that any of this looks democratic, fair, due governing procedures, regular order, et cetera, all these phrases we use to say, as our mutual friend Aziz Huq, writes in a recent book with Oxford Press, rule of law, the ideals of a rule of law government, a government where you can trust that judges will be impartial and so on. A lot of another thing I would emphasize, Peter, here is obviously the stock market is slipping regularly, and Trump has embraced apparently the notion, well, maybe we'll have a recession, but ultimately we'll be better off, he seems to be saying. It is the economic messages here are going to come in thick and fast in the next few months, I'd wager. And what they do to this impulse to be, how would you say it, impulsively all-powerful is a real question for all of us. But it sounds like you do fear a bit of a coup as these years go forward.
So I would say, a couple of things. One is Trump will say things that sound ridiculous, and in part he will do it as distraction. I mean, every minute that we spend focusing on whether we're going to occupy Greenland is a minute we're not focusing on, firing huge numbers of people from the Veterans Department of Veterans Affairs, or
taking away Medicaid,
right, or stopping, George W. Bush's really great humanitarian contribution, which was aid to stop the spread of HIV in Africa. So partly it's distraction, but if anybody tells Trump, oh, I bet you're not being serious, he doubles down. And one of his jokes is, maybe I should have a third term. Maybe I should have a third term. I'd like to think that he isn't thinking that that's possible. And I honestly don't think mainstream Republicans would stand for it. If so, then then there's no point in talking about anything that we're talking about. But I will say, so here's a problem. The other big case involving Trump in 2024 was called Trump versus Anderson. This is the case involving the effort in Colorado to keep him off a presidential primary ballot because of Section 3 of the 14th Amendment, which says, if you're a previous office holder who swore to uphold the Constitution and engaged in insurrection against the Constitution, you can't hold federal office. And the court, again, in a Roberts opinion that went further than it had to in order to resolve that, seemed to say that states have no role in keeping federal candidates off the ballot, which raises the question, what if, a 32-year-old wants to run? What if a non-citizen wants to run? Or what if somebody wants to run who is disqualified from having a third term constitutionally? Now, it could be that the court would say, oh, we were just talking about things that are, kind of areas for discretionary, potentially non-uniform judgment of the Constitution. We all know if somebody's been president twice before. We all know if they're 35 years old or not. States can keep those people off the ballot. But that's not what they said in Trump versus Anderson. So there are scenarios that, you can imagine people playing out. And the folks that Trump pardoned, for their activity on January 6th, they're willing to stand by and stand ready. I would also say, just in terms of appreciating how prescient the founders were, one of the big objections to giving the president a pardon power was that if he should be involved in conspiracy against the United States, he could pardon his co-conspirators. And, there was a time when you would just say, oh, what are we talking
Crazy.
about? Right,
Crazy. Right? Yeah.
And Hamilton made the argument, but it was important to have the pardon power because there might be periods of strife in which having mass amnesties were kind of critical to keep the peace.
A couple of questions, Carol. You haven't joined in for a minute or two, but I gather just from what's going across my screen in these, we've got about 9 minutes left because we usually stop pretty much on time at 5:30. There are a couple of questions, as one might expect, about faith and hopefulness in this regard. Are you talking to a couple of gloomy-eyed cynics who just see, like Cassandra, that all sorts of trouble and no relief is ahead? I do think it's a sadness of people my age and Peter's that as we face mortality in the latter chapters of our lives, we're facing a country that does not, for the moment, seem to be headed in a good constitutional and world citizen direction. But I speaking for myself, and I'm pretty sure for Peter, I'm somewhat hopeful. I'm hopeful that the courts will draw enough. I mean, take birthright citizenship. Both Peter and I are pretty much convinced this will stand against all sorts of attacks, and maybe lower court judges who say it doesn't obtain. I don't think they can get it through Congress, and less likely to get it through Congress in a couple of years than right now. And two, I think there is. This will sound crazy, but I think both Peter and I have some faith in the how would I describe it? The sort of institutional commitments of people like Roberts and A.B. Coney Barrett, and that there will be a majority for democratic order going forward and for fairness. It may be a disappointing majority. It may be trimmed down way beyond what we would like, but I would think it would hold the line, and I hope that's true of the military too. Peter, as Trump ages, that third term may become. I mean, he's exactly my age, I should say, but he's a better golfer, but he looks in worse shape. I think as he ages, that third term looks as dubious as, to be honest, President Biden's second term looked a few months ago. Where are you on hopefulness in terms of this discussion?
Tom, first of all, as I look at you, I do want to know in which closet is the painting in your home that is aging, because you look too much like the guy who sat up the row for me in 1975, but 1974. But putting that,
well, thanks for the compliment. You're pretty spirited yourself.
So on the particular issue of birthright citizenship, I want to say I'm hopeful, but maybe not for as rosy a reason as you suggested. I'm hopeful because I think the originalist case is overwhelming. The argument, for this sort of revisionist understanding of what it means to be subject to the jurisdiction of the United States, that's what they're hanging it on. I think it is just so demonstrably bogus, given the actual history of the debates at the time, which sort of anticipated, that this kind of thing would come up. But if the case gets to the Supreme Court, it's a chance for the court in a way that would not compromise their view of the unitary presidency. Like you say, you could have all the unitary presidency you want and still have birthright citizenship. Right. So they could show their originalist bona fides, supposedly, by doing the right thing on birthright citizenship. That doesn't necessarily tell you that they're going to do the right thing on these unitary executive questions. There are legal reasons to be hopeful. I think on the specific things about control of agencies, I do think the court is going to be reluctant to come up with something that invalidates the Federal Reserve System. I don't think they want to be responsible for making the United States the one country in the post-industrial world that cannot have an independent institution in charge of controlling the money supply. That would be quite the radical move. And so that may be enough for them to say, we're going to leave multi-member independent agencies alone. But what gives me hope, honestly, and this is why, when I came to NYU as a scholar in residence, originally, I wasn't being asked to teach. I didn't volunteer to teach. And then they found themselves short of a common law teacher once, twice, 3 times. So, I always say I have enough grading in me left to do 1 course a year. And so what gives me optimism is talking to people who are much, much younger than we are. They are creative. They understand the information environment in which they're operating in ways that, are sort of beyond me. They have very good values. They are pretty good bullshit spotters. And, as the song says, the children are our future. And it's really what they're doing, even outside the legal system, maybe especially outside the legal system, in terms of communicating, innovating, coming up with new ways to intensify our democratic commitments. That's what makes me hopeful.
Well, that's probably a good place, Carol and others, and all of you who are listening in to end. I certainly, as a teacher, I have some faith in my students. I think human nature is, by our natures, I think we are, the power can corrupt, and wealth can corrupt. I mean, all sorts of things can corrupt us and lead us to bad ends. But I'm putting a little bit of faith in Trump's age. and I do put a little bit of faith. I mean, I know it's odd for somebody who's a liberal to put faith in the conservative majority on the Supreme Court, but we really only need 2 from the rightward side. And I don't like to use the word conservative when I'm talking about reactionaries, because I often see them as not conserving anything, not the environment, not our constitutional tradition, and so on. I'm very opinionated about that. But to answer those of you who are worried, I do have some faith that we will get through this, and that we will, I at least will age out, painting on the wall or not, Peter, and we will age out with some hope about the United States and its form of government. It ain't perfect, but it's a pretty solid structure and has lasted thus far and will endure, I believe, beyond Elon Musk and beyond Trump. Peter, I want to thank you with all my heart. It's great to be in conversation a bit, like back in law school days. I think you're a great teacher and a great scholar. I sold out to become an administrator long ago. I was a young law school dean in Ohio, by the way. Yes. But thanks to all of you listening in. And if you have any friends who are mad at Ollie for limiting this, just remind them that within 24 hours or 36 hours, we'll send out a link so they can hear from Peter and from me too. Thanks so much and have a good night. And Peter,
thank you both.
It's been a pleasure.
Thank you,
Tom.
Carol.
Bye-bye. Take care.
Bye, one and all.